All right, let's dive into a legal case from the 1850s that, on the surface, is just about a broken piece of metal. But, believe it or not, the decision in this one single dispute has a massive impact on pretty much every contract you make today. We're talking everything from huge business deals all the way down to your online shopping.
Yeah, I know. It's a weird question, right? But that's the mystery we're going to solve today. There is a direct line from a busted steam engine part in Victorian England to the terms and conditions you agree to with a single click. Just stick with me, and I promise the connection is going to blow your mind.
So our story kicks off in Gloucester, England. I want you to meet a man named Hadley. Now, Hadley owned a very successful city flour mill, and it was powered by this big state-of-the-art steam engine. This mill wasn't just a business for him. It was his entire livelihood. It was the heart of everything he did.
And then, boom, disaster. The engine's crankshaft, this one single crucial component, snaps clean in two. And the effect was instant. The whole mill just stopped. The grinding stones, the conveyor belts, everything went silent. Hadley was losing a ton of money every single hour the mill was down. His only move was to get that broken part to a manufacturer so they could use it as a pattern to make a new one.
Okay, so Hadley needs a delivery service fast. He goes to a company run by a Mr. Baxendale who had a reputation for being a reliable carrier. And you'd think the arrangement would be totally straightforward. Hey, take this broken part from here to there, and please, do it quickly. Simple, right?
Well, here's where it all goes wrong. Hadley's employee was told the crankshaft would get there the very next day. But it didn't. It didn't show up for a full week. 7 days. For 7 agonizing days, Hadley's entire business was completely paralyzed, all because of a shipping delay.
And this, right here, this is the heart of the whole problem. You see, there was a massive disconnect between the two guys. To Hadley, the miller, this wasn't just some random package, it was the lifeline of his whole business. Every single day of delay was a financial disaster. But to Baxendale, the carrier, it was just another job. Okay, transport a broken piece of metal. He had no clue that an entire factory was just sitting there, dead in the water, waiting for it.
So, of course, Hadley sued. And he wasn't just suing to get his shipping fee back. No, he sued for £300 in lost profits. That's a huge sum, basically tens of thousands of dollars today. His argument was simple. The carrier's delay directly cost him a week's worth of business. In legal terms, these are called consequential damages.
So this whole mess ends up in the courtroom. And what happens next becomes a landmark moment in the history of contract law. Nobody saw it coming, but the judges were about to lay down a rule that we are still living with today.
Okay, so this is the moment of truth. It seems pretty clear, doesn't it? The carrier messed up, he was late, and because of that, the miller lost a bunch of money. So should the carrier have to pay for all those losses? What do you think?
And here is the big twist. The court actually sided with Baxendale, the carrier. They said he was not responsible for the mill's lost profits. And their reason boiled down to one key phrase. The massive losses weren't something that both parties could have fairly and reasonably contemplated, or in other words, foreseen, when they shook hands on the deal.
You see, this decision wasn't just about Hadley's broken crankshaft. The court used this case to create a whole new test for figuring out what damages someone is on the hook for when they break a contract. And this became famously known as the rule in Hadley v. Baxendale.
And that entire test, that whole new standard, it all hinges on one powerful idea: foreseeability. Put simply, it means you can only be held responsible for the kinds of damages that a reasonable person could have actually predicted would happen if the contract got broken. It's not about what did happen, it's about what you should have known might happen.
So the court laid out this two-part test. Rule 1 covers the obvious stuff, the damages that naturally and directly result from a broken promise. But Rule 2 is about special, unique damages, and it has a huge catch. You are only responsible for those if the other person told you about those special circumstances beforehand.
So, let's bring this right back to our story. Hadley never actually told the carrier's clerk, hey, my whole mill is shut down and this is our only crankshaft, so you gotta get this right. For all the carrier knew, Hadley might have had a spare part sitting in a closet. And because those special circumstances were never explained, the massive lost profits just weren't foreseeable under that second rule.
Now, this might all seem like a really interesting piece of legal history, but trust me, it is so much more than that. The ghost of that broken crankshaft is literally everywhere in our modern world.
I'm serious. This principle of foreseeability is one of the absolute cornerstones of modern contract law. It's buried in the fine print of your software agreements, the terms for your delivery services, even your employment contracts. It's what sets the boundaries for what companies are responsible for when things go wrong.
Let me give you a perfect modern example. Imagine you order a pizza for a big party you're throwing. If the pizza shows up an hour late, you might get a refund, right? That's a natural, foreseeable damage. But you can't sue the pizza place for thousands of dollars for the emotional distress of a ruined party because they had no way of foreseeing those special circumstances.
But on the other hand, this is exactly why really important business deals are so different. If a company is shipping a critical part for a factory's assembly line, you better believe the contract is going to spell out the massive penalties for every single day of delay. They are communicating those special circumstances right up front, which makes those huge potential losses totally foreseeable and, more importantly, legally recoverable.
So, what's the real legacy of Hadley's broken crankshaft? Well, it all comes down to communication and managing expectations. This case forces all of us to ask what's reasonable and what's known. So the next time you go to click I agree on some terms and conditions, just take a second and remember this story. Because in the world that Hadley and Baxendale helped create, the big question is always, what consequences are truly foreseeable?